Okay, can you start?
Just started.
I'm certainly interested to hear if you have clients saying anything about it. Is anybody getting or obtaining buyer representation agreements? If you're working with a buyer, you should have one, right?
This weekend, but then I linked my buyer up with our lender.
Uh-huh.
And then she made him realize that he's too broke to buy a house right now.
It's too broke to buy a house, okay? Don't use that lender, right? Okay, so nobody's getting buyer representation agreements. That's gonna all change quickly. Today's July 30th.
There's an article.
Mark,
today.
well, you didn't raise your hand. You always get a buyer representation agreement. Is that a yes or no?
Yeah.
Okay, they couldn't hear you. I could see your head nodding.
There was an article on Market Watch today saying that the real estate market's going to change and consumers are going to save millions and millions of dollars.
They're gonna save millions and millions of dollars. Huh?
Commissions are going to drop.
Is Karam here? Hey, Karam, you want to share with us the most recent commission that you obtained on your listing agreement, the revised agreement? Which you've got so many, I know. My understanding is he used the new residential listing agreement and he has a 4.5% commission on there, right?
Yes.
And that is, remember, the new residential listing agreement does not in any way suggest that you're sharing any compensation with anybody else. How did you do that? Uh-huh.
About 4.5%.
You did.
So I put it in.
Are they under the impression that you possibly may be paying compensation to the buyer's broker? I'm just curious.
No. that
No.
Made it clear that there's nothing going on. Things are changing.
Did you tell them that possibly the buyer may, on behalf of their broker, ask the seller to pay the buyer's broker's commission?
Yeah, I explained a little bit about it.
Okay, very little.
Yeah.
That's okay. Just curious, you know, how this is all happening.
When it comes to it, that.
Okay, all right. Good, that's helpful for me. I think it's gonna be helpful for everybody. Okay, 10 o'clock, let's begin. So what is taking place right now? The rollout has been terrible, in my opinion. Right now, as of July 24th, new forms have been dropped. The purchase contract has been modified. The buyer representation broker commission agreement has been modified, although the MLS has not been modified to reflect the fact that there is no longer an offer of compensation. So currently on the MLS, there's an offer of compensation on there for the buyer's broker right now. But when you look at that listing contract, in no way does it have any discussion or a sell to fill in compensation that will be offered to the buyer's broker. So we've had people that question that. We've had people that have taken a listing contract since the change in the forms, but the forms have come out before the obligation to no longer offer compensation on the MLS. That has occurred already, so it makes it much more difficult in regards to your presentation. And that's why I was interested in asking Karam. He took a 4.5% listing. The listing contract does not in any way suggest he's obligated to offer compensation to the cooperating broker. So a couple of things that are happening right now, July 30th, that's today. There is a concessions in price field, and it's going to be a yes or no response. And all it's doing is giving an indication of whether or not the seller is willing to pay any of the buyer's closing costs. In no way can you in any way suggest that any of the money is going to be used to pay for commissions, even though commissions are considered to be closing costs. And it's just going to be a drop-down field, as a matter of fact. Are you willing to pay concessions? Could be yes or no. There's no obligation, no contractual obligation for the listing agent or the seller to pay those concessions that may be represented on the MLS. August 13th. So I'm not going to talk about Flex MLS. We're not really involved with that. All buyer agent commission fields will be removed from Matrix and Paragon. So if you have a compensation agreement or you've been offering compensation through a listing contract or you're working with buyers, keep in mind as of the 13th, that field will be completely eliminated and no longer will any compensation be offered on the multiple listing service. Rules and policies become effective then, which is so strange. They've jammed these new forms down our throat, but the policies and rules aren't effective until August 13th. So confusing for me, yes. Confusing for your consumer, absolutely.
Not to mention all these dates they threw at us. They said August 17th, now it's August 13th.
Yeah,
and then
it's changed.
Yeah.
It continues to change, right? And then there's going to be warning messages that will be added to the listing input to tell users that any offer of compensation to a buyer's broker will no longer be permitted. So you might see that. And then, of course, now we have a new fine schedule. Fines will be imposed on all listings that attempt to indicate forms of compensation. So as a listing agent and you anywhere in the MLS offer compensation to the cooperating broker, and I'll go through the fine schedule, but I'll tell you right now, it's $2,500. And then the required concessions field, before we would type in or insert an amount associated with the concessions, now that's becoming much more detail oriented. Concessions, if you're the listing agent, will consist of the following: closing costs, which would be escrow and title fees, property improvements, so repairs, for example, if you've given a $5,000 credit towards repairs, financing costs if you're paying loan origination or points, and then buyer broker fees. That's another field in which the listing agent will be required to disclose how much the seller paid to the buyer's broker.
Wonder how they're going to be able to monitor that.
I don't know how you can monitor all that, right? That's a problem, right? So we talked about the warning fields that are to go in, and then fines will be imposed on any listing that in any way suggests there's an offer compensation on the MLS. It doesn't prohibit you from speaking directly to an agent or advertising it in some other method, but if it's associated with an IDX site, a VOW site, or anything from which information is derived from the MLS, that is a violation. That violation is a $2,500 fine. And as of January 1st, it's going to be a violation of California law. So the implications are going to be far greater. That would mean the Department of Real Estate is going to come after us for those violations in which you're offering compensation on an MLS related website or IDX website. And then compensation agreements, obviously you're going to be able to negotiate that. But when the change takes place August 13th, currently there's compensation being offered to cooperating broker. But as of the 13th, certain fields will be eliminated. So if a property is listed as coming soon, active under contract, hold or withdrawn, the compensation that was previously offered will no longer be represented on the MLS. However, as of the 13th, if the property was pending, it will show the compensation that was being offered. But if you move a listing from pending to active, then the field's going to be eliminated. If it's a closed file, it's going to be still showing the compensation that was offered, expired or canceled. So that's for historical purposes only. And then there are other changes to the rules. I'll just go over them briefly, but I want to go over the details as we go through this. So Rule 7.15, unilateral contractual offer of compensation will be renamed and revised to no offers of compensation in the MLS. Changes to offer of compensation to all broker participants has been renamed and revised to no disclosure of listing broker total commission. We'll go through the details. Section 9.1, showing and negotiations has been renamed and revised to showings. And then there's also a note, a signed buyer broker agreement will be required before showing a property. And keep in mind, if we'll go through the details, but if you don't have a signed buyer broker agreement, you can't show a property. And you're subject to a $2,500 fine if you do show a property, but the buyer representation agreement. And then also, if you're representing a buyer and you make an offer to the seller and you ask the seller to pay the buyer's broker's commissions, if there's not a buyer representation agreement signed, the seller will have no obligation to pay the buyer's agent's commissions. And if you don't have a representation agreement, that also means the buyer has no obligation to pay you. So you get nothing. And then how are you going to get paid? Anybody know?
Through escrow.
Well, through escrow, yeah, that's typical, right? There aren't too many options right now. So the options are when you submit an offer, the buyer's gonna be negotiating commissions on behalf of their agent. So that's an option. There's a possibility, we're not precluded from, as a listing agent, to offer compensation to the cooperating broker. So that's not going to be illegal. But how do we effectuate that? So that's going to be another issue. And then that gets back to the listing contract, because right now the current listing contract does not have a clause in it that obligates the seller to pay any commission associated with the buyer's broker. There's no obligation whatsoever. Do we consider at some point in time modifying the listing agreement? Possibly. We may add something to that that will allow that. But I think we need to wait to see what's going to be taking place to see if there could be more lawsuits forthcoming.
If a buyer doesn't bring in their agent's commission into escrow, will that hold up the escrow?
If a buyer what now?
Doesn't bring in their money for the commission for their agent, is that gonna hold?
If
up
they're the ones that are
escrow?
paying for it, well, it's like, that's their problem, right?
It-
But
it
of course,
doesn't
on
hold
the
up the
buyer representation agreement, the BRBC, it asks the question, Mr. Buyer or Ms. Buyer, do you have the funds available to pay my commissions? And if they check the box no, then they're not going to have to pay you.
But can it hold up the close of escrow?
Hold up the close of escrow, it may never close if they don't have the money. Yeah, absolutely. I think that would be something, is we're, as the buyer's agent, we're going to submit a demand to escrow. What is that demand going to consist of? It's going to be the fourth page of the BRBC. It's going to show on that fourth page, on the buyer representation broker commission agreement, pages 1 and 4, it's going to show exactly what the commission is that the buyer has agreed to pay. So Carr is suggesting that what we submit to the listing agent if necessary, or to escrow, the fourth page of that agreement, to show the amount of money that the buyer has agreed to pay to me as the agent representing the buyer. So that's something you should probably get accustomed to, as a matter of fact.
So when we submitting the offer to the seller's listing, the listing agent, we have to send it to the offer and the BRBC together.
You do not. You do not. So when you submit the offer to the seller and you're asking the seller to pay the buyer's broker, buyer's commissions, since you're the agent representing the buyer, it's going to state in that the seller payment of buyer's broker addendum that's going to be attached to the residential listing agreement, that in no way is the seller obligated to pay more than what is shown on the buyer representation agreement. So they may be willing to pay 3%. You may have negotiated that successfully, but when it comes down to it, that seller has no obligation to pay more than what's on the contract between you and the buyer. And the only way you can document that is to provide a portion of that agreement subsequently when requested. So I do want to go over the rules and policies. Any questions about that before we go on? I can't, first of all, oh, I'm sorry. If there are questions, please.
I just wanted to understand, if buyers are getting a loan, the lender should calculate that, probably like a 2.5%, whatever, 3%, towards closing, towards that agent's fees and those kind of stuff. Shouldn't be the thing now?
Well, I guess the question is, that's going to be dependent upon the negotiations between the buyer and the seller. If the seller is willing to pay those commissions, or if the seller refuses to pay those commissions and the buyer must come up with that money, that would be a part of the buyer's obligation for the down payment and closing costs. And keep in mind that that is not a contingency of the purchase contract. I think that's a very good point. So if the commissions suddenly are $30,000 that a buyer must pay because the seller refuses to pay, they're also going to have to demonstrate that they can't cancel because they don't have the $30,000 to pay you. Because they're supposed to have sufficient money to cover the closing costs and down payment. That is a contractual obligation. So how lenders are going to look at that, that's a good question. I think they probably should look at it from, say, if you can't get the seller to pay for the commissions, then you may not have a sufficient amount of money at this point in time to close the deal. I may be able to qualify you for the loan, but you may not have sufficient funds to close. And if you don't have sufficient funds to close, it very well can result in you defaulting and being in breach of contract. Because the down payment and closing costs are not a contingency of the contract.
So it's important always, if they're getting a loan, we check with the lender to see what would be the.
Yeah, and I think from a seller standpoint, if a seller refuses to pay the buyer's broker's commissions, they're going to lose a buyer. That's the other aspect too, in terms of how you're negotiating it. Yeah, and maybe you increase the purchase price.
Yes.
That's really what. That's VA loans are very common with that. So when you submit an offer, you may have to even offer more to get the seller to pay the buyer's broker's commission. But I think it's all going to be market driven. What's happening currently, it's still a seller's market. Although we're seeing a decrease in regards to the accelerating increase in values.
Sure. Is there a way, I asked Carlos last time, to install the commission for the buyer?
To install a commission for the buyer?
Yeah,
So
from the buyer.
installment pay,
to the
absolutely
agent,
not.
sorry.
No.
It should be cash.
Yeah, listen, we don't want to get into recording a deed of trust against the property. Not only that, just think about it. If we were to say, we want you, Mr. Buyer, to pay us commissions, but we're going to allow you to make installment payments. So one of two things is going to happen. We're going to have an unsecured note, and we're going to have to sue them individually to recover that money, or it's going to be secured against the property, and that's going to be considered a loan. And a lender is going to include that when qualifying them for that loan.
Yeah.
Because it's going to increase their debt to income ratio.
Yeah.
So I don't see how, at least me personally, would ever consider engaging in anything like that. You know, taking these notes, and then I'm not going to pay you until I have the money in my hands.
Right.
I'm not going to chase these people after the fact.
I have a question from Ryan up there.
Yes, Brian, you can ask. So when you're taking a buyer, you can ask the agent if there's any commission being offered. But if you ask that question right now, the listing agreement does not in any way suggest the seller is obligated to pay. It may, in the listing agreement, it asks if the seller is willing to pay a concession. It's just, are you willing to pay it? Yes or no? It's meaningless. So I would suggest contacting a listing agent, say, are you willing to do that? And if you are, but it's meaningless until you negotiate that in the purchase contract. But why wouldn't you? And I think, you know, what's taking place with the lawsuit, the concern that's part of the concern associated with the litigation is steering, because if we could actually sort based upon the commissions that were being offered to us as the cooperating broker. That's no longer going to be available. But if I'm a buyer and I'm looking at a listing and I see that the seller's willing to offer a concession amount, I'm more likely to look at that property, because maybe I don't have to come out of pocket for my buyer's broker's commission. And I don't know if I'm a listing agent, if I'm going to be, I think you always have to make the seller aware that I think in 100% of the cases, the buyer is going to be asking the seller to pay the buyer's broker's commission. I can't imagine that just not happening. Why wouldn't you ask that? Unless the buyer just has so much money, it doesn't matter, but it's all going to be the same to them. Maybe if it's an all cash offer, maybe they think that makes it appear to be a more aggressive offer. But if as you as a listing agent, you should be looking to see what the greatest net amount is to the seller anyways, when helping them decide how to look at any of these offers.
So Ryan's asking that, he knows you can't put the commission on the MLS, but can you put it on email, social media, and Zillow?
Yes, you can. Just as long as it's not anything associated with the MLS or an MLS IDX site or a VOW, virtual office website. So yes, you can do that. But Ryan, the question is going to be, it is meaningless, Ryan, because now it is meaningless. Today, if you see the offer of compensation on the MLS, it's called the unilateral offer of compensation, right? They're obligated because we all are members of realtors. We signed a contract. We're all obligated to the same thing. Whereas now there is no contractual obligation. So if a listing agent tells you the seller is willing to pay a commission to you, Mr. Buyer Broker, I'm not sure at this moment in time how we're going to document that obligation. We can do it through the SPBB, but now the CBC, the Cooperating Broker Commission form, something that at least obligated the listing agent to pay me, that's been eliminated from the MLS now. It's no longer even available. Good questions, Ryan. Okay, so let's go through the rule changes so we have a better idea. And please, any questions that you have, you should be forthcoming, and don't feel as if any of your questions are invalid, because this is all complicated. It's a dramatic change in regard to our practice. So Rule 7.15, unilateral contractual offer has been renamed to no offers of compensation in the MLS. So before we had an offer of compensation to no more offers of compensation. A listing broker may not input or otherwise the MLS in any capacity or in any field, media or document uploaded to the MLS to offer or convey any amount or any willingness of a listing broker to share a commission with a buyer broker, or for a seller to offer a specific compensation amount to the buyer broker. So nowhere in the MLS, anywhere, private remarks, public remarks, can you suggest as a listing agent, I'm willing to pay you as the buyer's broker, nor can you suggest that the seller is willing to pay commission. They can offer a concession, but if it's in any way associated with a commission, it's a $2,500 fine, and then it's going to be a violation of California law January 1st. But this gets back to Ryan's question. So nothing in this rule shall prevent the listing broker from inputting any amount or invitation from seller to consider any concessions that may be requested by a buyer in an offer, as long as such communication of a concession does not limit or condition the concession of being used to pay any buyer broker or other buyer representative. So no way, remember, there's a concession field. It's going to be a dollar amount. You can say, or just a yes or no answer, the CIP. You can just say yes or no. The seller is willing to make a concession. Yep, concession. And the concessions field can consist of a dollar amount or can consist of a percentage, but there's no contractual obligation. All it does, it's just sending a message, nothing more than that. Let's see. And then you said, sorry, last question, you said if the buyer has an agreement,
Question.
commission offered to buyers will be worked up in the loan. So what I'm suggesting, Brian, is that you just, if the buyer doesn't have sufficient funds to pay your commission as their agent, increase the purchase price, ask the seller to pay those commissions.
Is the best bet.
It's the best way. And then of course the seller, if I'm a seller, I'm going to be saying, well, is my property going to appraise? I'm allowing you to increase the purchase price, so I pay your agent's commissions. And if it doesn't appraise, does the transaction proceed?
But doesn't the buyer come out of pocket anyways if it doesn't appraise and they have to pay the gap? So it's either pay the commissions at a lower.
Well, they don't have
price.
to go forward if it doesn't appraise. That's the problem. Then you got the property tied up.
Yeah.
You can use the appraisal gap, right? So you can always say if I'm off, if the asking price is $1 million, I can say it only has to appraise at 950,000, but I think the negotiations, it's going to be something you have to really give consideration to if you're increasing the purchase price to cover the cost of the commissions the buyer's obligated to pay. Is it going to appraise? Because the listing agent should be looking at it reasonably, thinking it may not appraise at that purchase price. And the transaction is going to fail, or what's likely going to happen, the buyer's going to renegotiate the purchase price.
So as a listing agent, you have to be pretty careful to look at the whatever financials that the buyer's sending in, if they do have enough money to pay their commissions.
Yeah, that's a very good point. So when you're evaluating a buyer as a listing agent, you should be looking at their proof of funds and making a determination whether or not they have sufficient money to cover the down payment and all closing costs, including those commissions. Any other questions? Do concessions get displayed on Zillow? No, they do not. Zillow is an IDX website just like us. Now, so keep that in mind. If it's associated with any distribution of information from the MLS, it cannot be displayed. Now, I think where it could be displayed on Zillow is if you have the only way you can display commissions being offered on Zillow is if it's a lease agreement or an offer to lease a property. Now, the MLS rules and regulations, they haven't fixed this yet. Everyone is really obligated to post any lease or property for lease on the MLS, but for some reason, CRMLS does not enforce that. You can actually publish a for lease listing on Zillow without being in violation of the clear cooperation policy. So that's a possibility. And in that case, because it's done in the MLS, you could then post an offer of compensation. But if it's a for sale property, but then one day of marketing a property, you have an obligation to post that property on the MLS. So the clear cooperation policy requires putting any property for sale within 24 hours of marketing that property on the multiple listing service. So if it's for sale, no. If it's a lease listing that's never been on the MLS, then yes, you can offer compensation on that lease listing on Zillow. And Jeff, let's see, but you can still counter the buyers to waive the appraisal contingency. Absolutely, you can do that at any time. So there's nothing wrong with that. I think that's just going to depend upon market conditions and if it continues to be a seller's market. Sarah, are you seeing a lot of people waiving appraisals now?
Yeah.
Are you? Okay. Is that something your sellers want? You're negotiating? All right, so it's still happening quite often. And then showings and negotiations rule 9.1. It's been renamed and revised to showings and now reads, sorry to read all this to you. Buyer broker shall follow all showing instructions as set forth in the MLS. Buyer broker shall only provide access for showing, touring, or inspecting a listed property to a client with whom the buyer broker has a written agreement that includes the following in a conspicuous location: a specific objectively ascertainable compensation amount or rate, including how any such amount will be determined, and the amount of compensation may not be open-ended, such as buyer broker fee shall be whatever amount a seller or listing broker is offering to pay buyer broker or buyer. I'm going to go through this, by the way. And a term that prohibits buyer broker from receiving any fee or compensation that exceeds the amount or rate in the agreement with the buyer, regardless of the source of the payment of the fee, and a statement that broker fees and commissions are not set by law. That's already in there. So nothing in this policy shall impose any restriction or requirement upon the listing broker. So what this is saying, you can't show property without having a representation agreement. If you do, it's a $2,500 fine. January 1st, it's going to be a violation of law. And then in addition to that, the buyer broker agreement, it's going to state the maximum amount of compensation you can earn. You may say 2% in there, and if the seller's willing to pay 2%, the listing agent is willing to pay 2%, the only amount that you can collect is 2%, which is in that buyer representation agreement. So no matter what, There's a limitation in regards to how much you can earn on a transaction now. Just as long as it's specifically stated in a buyer representation agreement. I think that's the most important thing. You're gonna have to do that anyways. You can't show property without having a buyer representation agreement. So it can be limited, for 1 to 3 properties. There's one form that addresses that. It can be the BRBC, which is non-exclusive, meaning I can just protect myself for this property or maybe Orange County, but then an exclusive agreement for the area you define that protects you for any property the buyer buys. But if you say, I want to be protected for any property the buyer acquires in California, it's probably not going to be enforceable. If you say Orange County, it's probably going to be enforceable against that buyer. And I can assure you, if a buyer goes forward, we have a representation agreement, and they buy a property of somebody else, I'm going to sue them. I am not going to take the position of laying down with any of these people. All right. They sign a contract now, they need to be aware. So that's something you can count on for me. If you're representing somebody and they go with somebody else and you're cheated, we're going to be sure to do everything we can to protect you, because you're working hard for this. So people have to understand these contracts are enforceable. Let's see. So we talked about that. And then rule 13.7, listing broker's permission has been revised. No MLS participant or subscriber may enter a property or open a lockbox without the listing broker's permission. Permission may be granted by the listing broker by specifying permission to use the lockbox through the MLS. So appraiser participants are expressly prohibited from using lockbox keys to enter a property without either the owner or listing broker's permission. So you can give permission to anyone to enter that property via the MLS. It's probably not that much dramatically different than what we do now. And then 19.2.21, I know we're all going to memorize this. No display of offers of compensation has been added. So participants and subscribers, that's us, shall not display on any IDX website or application controlled or operated by participant or subscriber any offers of compensation from either a listing broker or seller to any buyer broker or buyer representative on any property listing that is provided in the IDX feed, other than an advertisement of potential sharing of compensation on a property subject to an exclusive listing agreement with the displaying participant. So what is that saying? Once again, any IDX related site or anything associated with the MLS, there cannot be any offer of compensation to a cooperating broker. It's prohibited.
So Roy is asking if we can request more than one county on the BRBC.
I would say so. You can probably put more than one county, but if you specify 58 out of 59 counties in California, it's probably not going to be enforceable. It's awfully broad.
And are you really going to show properties in all those?
Yeah, you're right. Yeah, I think just being reasonableness is important.
And then Ryan's asking, does buyer's agreement also apply to leases? So I can't give keypad access if I don't have an agreement. Does that include open houses?
Everything we're talking about applies to tenant representation. So you must have a representation agreement for a tenant. You must do that. So it's no different.
And there's a form for tenants, specifically for tenants.
Yeah, tenant representation, similar to the buyer representation broker commission agreement. So the tenant representation falls under the same guidelines. There's going to be no offer of compensation on the MLS. So if you're showing a tenant, I don't see anything wrong with this actually myself. You waste a lot of time showing tenants property, then they leave you, lie to you, and then you get nothing. And then keep in mind, I think when you're talking about having buyers sign these buyer representation agreements or tenant representation agreements, you better be prepared to tell them why they should sign it. But regardless, they're going to have to sign with anybody that they work with. Do they want to sign one agreement with you to see one property and continue signing new agreements? They may very well sign more than one agreement and not understanding they're obligated. But that's something that we're going to do as a company. We're going to pursue those people. We're going to make sure that we protect ourselves if in the event they do that, and we're entitled to compensation.
And what if the lease is not in the MLS,
If the lease is not in the MLS,
the listing?
well, I think the dilemma is if it's not in the MLS, showing your property, it's probably okay because it's not associated with the MLS. I don't think that first of all, I wouldn't even put myself in that position. Is it going to be acceptable? Maybe, but then you're not entitled to anything anyways if you don't have a buyer representation agreement. So why not put yourself in that position? Because there's going to be no offer of compensation to you when representing a tenant, and it's not, there's nothing. There's no protection for anyone representing a tenant or buyer now unless you have that representation agreement signed with the tenant or buyer. You're entitled to nothing.
What about open houses?
Well, at open houses, that's good. Those are good questions, Ryan. So if you're a listing agent, you have an open house, you can allow people in. You should have a sign-in sheet. There's I think the OHNA, open house something advisory, and you collect their information. And what I would suggest is that what is suggested is that any potential buyer or tenant should be signing in that sign-in sheet. If it's somebody that's mom and dad that are just accompanying the kids just to look, and they're really not the buyers, you don't have to request that they sign the sign-in sheet. But if you don't have them sign that sign-in sheet, there's always a possibility that it could be construed as if there's an agency relationship. And trial attorneys just love this stuff, right? Oh, you didn't tell us. You gave me the impression that you're representing me. So at least with the open house advisory, open house non-agency advisory, I think that's it. It's telling them you're not representing them. And any information you give them is for the benefit of the seller. And anything you tell me, I can pass on to the seller. I don't have a fiduciary relationship with you. So that's what I would do. You can also have them sign a limited representation agreement. They don't have to do that, but if they want you to represent them, you can just have a limited representation agreement specifically for their property. But for an open house, you can let them in. Let's say they refuse to sign the sign-in sheet. Can you, as a listing agent, say you don't have access to the property? Yes, you can. There's nothing that forces you to give them access to the property. Now, we don't want to put ourselves in the position that someone claims that you're discriminating against me because I'm a white guy and I don't like white guys.
A lot of people don't.
A lot of people don't, right?
No,
So
it's
that's
not.
the other thing to give consideration to. But if you do allow somebody in that refuses to sign and they don't have representation, what is suggested is that the only thing you do is give them the property flyer assuming you have one and tell them I can't answer any more questions. Is Jeff Dreyer here? And Jeff Dreyer, he went through a list of things with me in regards to what he does on when holding open houses. And so he just points out all the different things that I am aware of that I can't help you with. I know the schools, I know the HOA dues, I know the taxes, I know all these other aspects about the property, but I can't tell you because I don't represent you. I think that was when he went, I think he has 7 different items that he automatically says that I think causes them to think, oh, you know what you're doing. So maybe I should consider having you represent me just at least on this one property. This is always my favorite part. Fines. These are new. The fine schedule has changed. We'll just go over the basics, but I want to go over through the whole fines, not the whole fine schedule, but these are all $2,500 fines that didn't exist before. 7.15, offering or conveying buyer's agent compensation in the MLS. So you can't offer any compensation. If you do, it's a $2,500 fine. Insufficient disclosure of compensation to seller or landlord. There's another $2,500 fine. Disclosure of listing broker's compensation. You as a listing broker cannot disclose your compensation. I don't know if we ever did anyways. Showing listed property without written compensation agreements with the buyer or an insufficient compensation with the buyer. Maybe it's not filled out properly. So once again, if CRMLS, and it's going to be your fellow peers that are going to report you, find out you're showing property and you don't have a compensation agreement, you're going to be fined $2,500. And then keep in mind when, because I still set our professional standards. What happens sometimes when people encounter fines, sometimes they can test those fines. That's great. Maybe they win, maybe they lose. But me sitting on that panel, if I find that they're violating the law, I can actually have the outcome of that hearing referred to the California Department of Real Estate. So those are some of the options to the panelists that are judging you on your behavior. So it's not just the fine, but if they're referred to the Department of Real Estate, the DRE will follow up on every single accusation, whether it's from a panelist or it's from a member of the public. And we talked about this, display of offer of compensation on any IDX related website. Someone brought up Zillow. Zillow, when selling property, they have a traditional IDX website. So there's no way you can populate that anyways for a for sale property. Maybe an individual owner who is not a realtor can publish that information, and they're not going to be subject to the same guidelines. Display of offer of compensation on a virtual office website. A vow is simply similar to an IDX website, except it has more history. And let's go through a few of these other things just because it's so much fun. And this isn't all related to the changes themselves, but 7.8, failure to input listing in MLS or register property. So we've talked about this over and over again. If you have a listing and the beginning date of the listing contract is today, but the effective marketing date is September 1st. If you don't register that property, you're going to encounter a fine. And the fine is going to be a minimum of $500 to as much as $2,500 or 1% of the value of the property.
If you guys are not sure when to enter into the MLS, you can come and ask us.
Yes. So for those properties, I mean, you can change the beginning date on a listing contract out in the future. That's great. But when you take that listing contract, I would always suggest having the beginning date as of the date of today, because you're protected. You may not put that on a that property on the MLS for a month. So during that month, you're protected at least. If you say the beginning date is a month from now, you're not protected between now and then. So if they sell that property, you're entitled to nothing. I'm just going over the largest fines because they have grown. Offering 7.15, and this is repetitive, offering or conveying buyer's agent compensation in the MLS. You cannot make any representation in any way whatsoever in the MLS that you're offering compensation to the buyer's agent. Insufficient disclosure of compensation to seller or landlord. That would suggest to me that the seller or landlord now has filed a complaint with the MLS stating that you, as the listing agent, did not adequately disclose the compensation that you're expecting me to pay. And then disclosure of listing broker's compensation. You cannot disclose that anywhere. And one other thing else, failure to obtain authorization to list in the MLS section 8.1. This is nothing new. But hard to believe, it has happened that listings have been put in the MLS without a listing contract. So not only is that a violation, but that is a Civil Code 1088 violation. So it's much more severe than you could ever expect.
It's not in our office.
And then failure to follow showing instructions. Carlos had this recently on a lease listing, right?
Yes.
You want to share with us what happened?
I had a lease listing, and one particular day, well, first of all, the showing instructions say contact agent to schedule a time and wait for confirmation. And this particular day, the owners were going to have some repairs done in the house, and they said don't allow any showings until after 5 p.m. today on that day. Well, an agent just showed up to the property without prior notice, showed the property. I tried calling her at the time, and while she was showing, didn't answer, and I reported her to the board. And that's a violation. That's 2 violations actually, for showing the property without permission and not following the showing instructions. So that would have been a $3,000 fine. She bothered me every day after that.
To withdraw
To
the
oh,
complaint, yeah.
God. She came to the office.
He felt bad. I wouldn't have felt bad.
Yeah. She had a leg brace on and she brought some kids in with her and
A leg brace.
she had all like yeah.
I started dancing in the parking
Oh,
lot
God.
after you came in, right?
Yeah.
Oh my God, yeah. Who are those kids, right?
Oh, she pulled those strings.
And then section 9, thank you, Carlos. Section 9.1, showing listed property without written compensation agreement with the buyer or insufficient compensation with the buyer. So please don't show property unless you have a compensation agreement. Not only that, why would you? Everybody's required to do it. Don't put yourself in that position. And then you cannot, remember, if you have a property, you take a listing, it's not going to be active till September 1st, but the beginning date of the listing contract is today. What's odd, you can show the property when it's in a registered status. You can do that. But once it's coming soon, you can't show a property during that time frame. If you show a property coming soon, you have 24 hours to change the status to active. But the fines are extensive once again. And then failure to be present when providing access to a listed property. Be sure that you attend with your client. Don't send them to the property alone. Don't unlock the property. Let them walk around by themselves, okay? That's an issue. Let's see if there's any more $2,500 fines, because those are the most commonly ones that we're seeing right now. And let's say we saw we talked about 19.2.21, display of offer of compensation, IDX websites, $2,500, or if it's on a Bob website. So they're going to be policing this. I think they're going to make examples of people as we go along here. And so I would ask that you follow the obligations, and not only that, but remember, because August 13th, the offer of compensation will no longer be on the MLS. If you're working with the buyer and you don't have a buyer representation agreement, after the beginning of 13th, you're not entitled to any compensation. In addition to that, after the 13th, if you don't have a buyer representation agreement, even if you negotiate with the seller or the buyer negotiates with the seller to pay the buyer's agent's commissions, the seller has no obligation to pay. Plus, the buyer will have no obligation to pay you because you don't have a contract. So if you're showing any buyer now, you should have them sign a contract because 13th is right around the corner.
Rich, well, I'm just curious, what would happen if on the 12th you submit an offer and you're using the commission and the MLA and they're countering back and forth?
Yeah.
And it takes a couple of days?
Yeah, that's okay. I think that goes to the existing rules. So Carlos is saying, what happens on the 12th? The offer of compensation still exists. I submit an offer. Well, you're protected.
Even if you're countering back and forth?
Even if you're countering back and forth, because it's based upon the date. As a matter of fact, to go to an extreme, if I call that listing agent today and I say I'm going to be submitting an offer, you're protected. You submit an offer the same day, so that is something else. They can't change the compensation on the MLS. Currently, they can't change it. You know, when you notify them in advance that you're submitting an offer. We've witnessed agents that would change the compensation that's being offered on the MLS after they were notified. It usually happens after you submit an offer. Sometimes we see changes, but most importantly, if you submit the offer, you're protected. You know, we just have to obviously document that. So they can't withdraw the offer of compensation on the MLS. Do we have any other questions? No? Sure, no questions. I've had to read this over and over to really understand it. So the 45-minute presentation probably doesn't do it justice in terms of the complexity associated with this.
And also to clarify for those that still are confused about it, if your buyer commits to paying you 2% and the seller pays 1% of that, your buyer's still on the hook for the extra 1%, for the remaining 1% of that.
That is correct. That is correct. Yeah. And no one has, well, it's interesting, Karan, you got a 4.5% listing. That's wonderful.
So what I am thinking is I don't probably work out all my clients know that on sales and 6% on the lease. So that's what I will, moving forward, that's what I will.
That's what you're gonna tell them.
Yeah.
Okay?
They all know about it already.
Mhm.
I will explain that, but, compensation. Then I will go case by case basis. How important is it to lease to this client and buyer, that I want to offer anything at that point? 1%, 2%, whatever.
Yeah, yeah. And then just as a reminder, if you have a listing contract and that current listing contract, you have specified there's an offer of compensation to the cooperating broker. Or by the close of the 12th, you need to modify that listing contract to reflect the fact that you are no longer offering that compensation on the MLS. And then the seller, let's just assume it's a seller, has an option. Well, do I just pay you that additional 2% or do I not want to pay that at all? So that's an option on that modification of that listing contract. Because the listing contract says it's going to be offered on the MLS. But if you can't do it anymore, then obviously you have an obligation to modify that contract.
In that example that Karam gave, where he's saying he's gonna charge 4.5%, and then let's say he wants to give some of his commission to the buyer's agent, let's say 1%. It's not the seller paying the commission in that situation, it's the agent paying the commission. So how would that work?
Well, that's there right now. Zip Forms has not given us any type of documentation to facilitate something like that. So what I would suggest in what your example is, if he's going to actually use a portion of the 4.5% to compensate the buyer's broker, probably should state or modify the listing contract to say, I'll accept 3%, and then the buyer negotiates with the seller to have the seller pay 1.5% to the buyer's broker.
Yeah, because the agent can't pay.
The agent cannot pay, right?
Yeah,
Yeah. It's not that it's illegal, it's just right now there's no platform for that.
not even with an addendum.
Yeah, and here we are now we're writing
Yeah.
legal contracts. I don't know if we want to get into that at this moment in time. I'm sure as things go along, we might give consideration to that. But I know and I think it's common with most offices, if there are often addendums that other offices submit that aren't part of the Zip Forms library, I'm always hesitant to have our clients sign those things. So now suddenly, if we're writing up a legal contract, do we actually have something that's binding or protected? So it's all something I think that's going to develop as time goes on. And it probably will have to develop. Just like we may want to take a listing contract and have the seller state that they're willing to pay compensation. We're not precluded from doing that. We're just precluded from offering compensation on the MLS. But the listing contract, unfortunately, does not lend itself to obligating the seller to pay the buyer's broker. There's no mention of that. So now you're going to have to add an addendum. You're going to have to add another form that even draws more attention to the fact that, well, you've got the standard form, but there's nothing in there that says that's obligating me to pay the buyer's broker. And then I've heard about this settlement. I don't have to pay the buyer's broker. So I don't know what the best approach is going to be. I think it's going to be something we're going to have to work out here. At least if they're aware that the buyer's agent is going to be requesting, the buyer, it's never the buyer's agent, it's the buyer requesting seller pay the buyer's broker. That probably comes across a little differently. And then remember, in the residential listing agreement, now there's even a field that states if the buyer is unrepresented and I help them, even though I'm not representing the buyer, you, Mr. Seller, are going to pay me additional commission. So that's an option that's available also. Is that buyers, and if I'm a listing agent and a buyer comes to me and wants me to represent them and they don't want to pay anything, I'm not going to do that. Why would I do that? Unless it's completely a buyer's market, get your own agent, or if you want me to represent you, even though I'm a listing agent, you're going to sign a buyer representation agreement with me. Why wouldn't you do that? But then when you do that, you're asking the seller to pay
But
the
you
additional
probably-
money.
You probably already know that they're willing to pay that, so.
Yeah, you probably know, right?
that into
Yeah,
the-
dual representation, right? Yeah.
Sticky situation.
So if you use the current residential listing agreement, which you almost have no choice at this point in time unless you have the desktop version of Zip Forms and did not update your Zip Forms library, just remember, if you use the current one, you have to put 0 in for the offer of compensation to the cooperating broker. Because unless somehow we figure out how to modify the current listing contract that was released July 24th. So, any other questions?
So everybody should be using the updated forms. Try not to go into your old transactions and just redo a transaction over that transaction because it's going to use the older forms. So create a new transaction as zip forms so that you download use all the newest updated forms.
Yeah, I think Carl's just saying if you use the copy function, if you copy a transaction,
Some people just go into their old transaction like a lease or something.
no,
And then
And use those
just,
forms.
yeah, they just type over the old contract, change the dates. And it's the old forms that are there.
got it. Well, if you use the former residential listing agreement, you can do that. And you can actually have the seller offer compensation, but it's not going to be an MLS. So you can't, if you fill it out such that you're obligating yourself to offer compensation in the MLS, it's going to be useless anyways. You're going to have to modify that.
Or you apply the template, then all the new forms get done.
But
Yes.
you have to update your template though. That's
On the
thing.
desktop version.
So whatever forms you have that are existing in your template, you have to delete those old forms and include the new ones.
No,
that
yes,
is not.
that's good.
Well, if the broker, if you're using
Oh,
the
the
broker
broker version,
version,
yeah.
it does update the
Yeah.
forms based with the templates that we use.
But-
But if it's your own individual license, the forms are not, and remember, template is just a series of forms you include to simplify your life. You know, I want to list a property. So you have all these forms in a template that are included when you create a new transaction. So if you're using your own individual license zip forms and you're using the template, it does not update the forms in that template. If you're using the broker edition, which we suggest you do, it will update all the forms within that template. So you're using the most recent forms. Anything else? It's just complete silence out here. When does it actually start? Well, Ryan. Well, thanks, Ryan. I look tan. So the forms are ready. The form changes took place July 24th. The implementation of the guidelines occurs August 13th. So on August 13th, the compensation fields will be removed for any actively marketed listings for coming soon, active, or on hold. But if it's in escrow, pending, closed, withdrawn, canceled, that will retain the information for history's purpose and nothing more than that.
For listings, you have no choice. You have to use the new form because that's what's available now.
Unless you've got the old form still.
Yeah.
You can still do that. But if you use the old form, then you're going to have to modify it by the close of August 12th. Okay, Ryan, hey, you wear red. Yeah, I usually get red, Ryan. Anyone else have any questions? Ryan, you did a great job with the questions today. You were prepared. On fire.
I think he's in Europe right
Is he?
now, is he?
I
I know he's on vacation until the week.
Actually, so. Well, he could be another Ryan. Could be anywhere.
He's not international.
Where are you, Ryan?
Hey, ma'am, later on fire in Nashville, living my best life.
There you go. Okay, not in Europe this time.
Okay, well, thanks for, well, the other thing we do for those people that are present, and Ryan, that does not include you. So we'll collect your business cards and we have movie tickets to hand out. You should have flown back for the movie tickets, Ryan. Everybody turn their cards in?
Everybody turn in their cards?
We can walk through the office if you want.
You have one? I know you just ordered them. so-
Yeah, not yet.
Just get someone's card and write your name on the back.
throw in there.
Viola, do you have a card? Zach, do you have a card? Okay,
Should we put
let's get
Zach's
some
name in?
temporaries. We have.
We
We'll
should put
grab
Zach's
some and
name
put
in.
your name on it.
Recording? I'll pick yours.
Okay, who needs one? Sam, Zach, and Viola,
Oh,
and Monique?
Yes.
Okay, let's see. Monique, I'll come see you in a minute. We're gonna write some names on it for you. Carlos, I'm gonna steal some of your cards.
He's gonna cross my name out now.
Yeah, right. You've got one, Viola? Go ahead, write your name on that one. We probably can close up.
Oh, I think they're watching. They want to see what's going on.
Okay.
I want to see who the winner is.
Yeah,
We
we
got
see the winners,
Zach.
yeah. Nothing
Well,
wrong with
Sam,
that.
you didn't have one, right? Yeah. All right. Think, is that everybody?
Okay.
All right, Carlos is gonna draw two.
Okay.
If you don't win,
I'm not
get
looking.
mad at him, not me.
Look at me.
So let's see.
Here, no, there.
Okay, there's one.
I never did this, share my screen. It's some of these things I wanted to share.
All right, Sam wins
Okay,
and Rima.
okay, fantastic.
So congratulations. Couple
Okay,
movie tickets for you.
Second time.
second time. So you live your
All right,
life.
don't
you know?
say that too loud or else they're gonna say you can't put your card in anymore.
Okay, well, thanks for coming, everybody. I really
Thank
appreciate
you
it.
very much, everyone.
Then we'll see you next week.